Good afternoon, everybody, as the numbers flood in. I hope everybody's well. We're going to start in a couple of minutes. We're going to wait until the numbers stabilize a little bit. We are expecting quite a few people. We've had hundreds of people have signed up to this meeting, so we are expecting a big crowd for it. Okay, we're going to, just to repeat for anyone, we're going to start in a minute or two. We're just going to wait for the numbers to stabilize. We've had hundreds of people have signed up for this session and people are still coming in. So we're going to wait for the numbers to stabilize and we will start in a minute or so once that settles down. I mean, one thing before we start, once we get going, we're going to go through the main areas that we've discussed, the issues that we've said that we're going to talk about in the email that went out and on the sign up page. If you have questions, we're going to take questions at the end, but please be thinking about them, and you'll see that in the bottom of the if you mouse over the bottom, if you're on a computer, if you mouse over the bottom, you'll see that there's a Q&A link and there's a chat link. If you've got questions, can you put them in the Q&A link? If you put stuff in the chat, there's no guarantee that I will see them. I mean, we will keep one eye on the chat, but there's no guarantee that your stuff will go in there. The meeting is being recorded, so I'm answering that one. The meeting is being recorded, and hopefully we'll be able to show it everyone. We've got someone saying that apologies, the camera isn't working. You'll be spared my lockdown face. That is fair enough, Marion. I'm sure it's not as crazy as mine at the moment. My lockdown hair, I've not been able to really find a barber. I did try a barber, but they just wouldn't have me. They took one look at it and thought, we're going to need a set of strimmer or something like that. Okay, so the numbers are stabilizing now. I think we can get started. Yeah, let's get started. Okay. Right, well, thank you very much for coming today. We've circulated 2 documents already. There's one called Guidance for Members on COVID-19 Terms and Conditions. And that's a document that was pulled together by a large-scale meeting of Bectu reps, where we went over what our advice to members is. Plainly, we're not in a position to renegotiate any of our agreements at short notice with the employers, and it's a very fluid situation, as you can imagine. The back to work situation is one where we know that an awful lot of our members have almost 2 attitudes in the same head to this. I know that everybody's really keen to get back to work and start earning money as soon as possible, but everyone is also really keen not to put themselves in danger, not to put their families and their friends in danger, and not to put the economy in danger. And I know that many of our members have concerns that, about any return to work, that, if any return to work causes a second spike, it'll actually do the industry more harm than good. So, so we've got those 2 documents. They've been circulated. This meeting is called Saying No to One-Sided Contracts. And it's really about this idea that freelancers invariably have one-sided contracts anyway. If an employer can cancel a contract at short notice, it gives them more bargaining power. what we want to do is make sure that that situation isn't made worse in the return to work. And there are some arguments that you can use that are both in your interests, and I believe in the interests of the industry, that you can make to stop employers being bad at management and doing things that could put the industry in danger. So I'm going to welcome the panelists. We have Spencer MacDonald, who is the Bectu's National Secretary. He covers the London Production Division and Regional Production Division, which is all of TV and major motion picture, factual, entertainment, outside broadcast, all of those areas, commercials, everything that is, production based. We also have Marion Scovell, who is the head of legal for Prospect and Bectu, where Bectu is a sector of Prospect. And Marion is going to be on hand to give us her legal wisdom and to be able to answer the many difficult questions that me and Spencer would generally probably make something up about. If our answers wouldn't have the quality of Marion. So Marion's on here as well. And we've got one of my colleagues, Paddy Emmond, is going to be keeping an eye on the chat and is going to be keeping an eye on the Q&A. So we've got those twin aims. We've got those twin aims of getting back to work as quickly as possible. You'll have seen that we've got some safe working documents that have been produced and they've been published. So we have a detailed document on safe working for TV drama and major motion picture. In fact, we've had more of an interaction with the industry than that. Spencer MacDonald's been working with the British Film Council. Spencer, do you want to have give people a quick walkthrough of all of the work that you've been doing with the BFC, but also the work that we as a union have been doing on pulling safe work guidance together as a prelude to our chat about terms and conditions?
Yeah, thanks, Paul. I suppose it's worth just winding the clock back slightly, just in terms of when the lockdown happened. So on the 23rd of March, when the lockdown was announced, virtually every single film and TV production stopped filming. From the 23rd of March, the signs were there already because there was loads of people that were going on hiatus. But from the 23rd of March, that was really where it all went off a cliff, and most of the productions ceased. From then onwards, there was a bit of a gap in terms of what we were doing, what the industry were doing to address that particular issue, because we had to wait for the government to decide in terms of what the guidance was, whether they were going to relax the advice. So in preparation for that, the BFC decided, I think it was around May time, that they wanted to put together the return to work guidance. So they started to do some work on that. We were an integral part in the putting together of that document, because they invited us onto the task force. There was only roughly about half a dozen to a dozen people that were invited on that, and then there was a much bigger group that were consulted. So we were quite we were feeding into that, and they were, if anything, they took on board in terms of the views and the responses from us, probably more than they did from most of the other organisations that were involved in it. And just to give you a flavour, there was roughly about 500 different organisations within the industry that were consulted over it. So they had 500 different contributions. And if you have a look at the document and you have a look at the work that we did on that, it reflects mostly, the feedback that we actually, gave to the BFC. So they're now on version, I think it's 2 or 3 now. So they've made a few alterations in the document. There's also the broadcasters document. We had less of an input into the broadcasters documents. That's the BBC, ITV, Channel 4, Sky, Pact. We did input into that, but not as detailed as the BFC document. That's, I think, on version 2. Again, there's the visual effects and post-production and animation document, which was put together by Screen Alliance. We fed into that document as well, and there is, so you will see in there some of the points that we put forward, which is helpful. And then finally, there's the APA and the Bectu document. So the APA document, I think, was the very first document to come out. And I think that's partly because most of the commercials did, to some small degree, carry on filming during the lockdown. So they wanted to make sure that if brands wanted to turn the corner and advertise more quickly, that they wanted to be the first to produce a document. So they were. So there's that document, and we inputted into that as well. And then finally, there's the Bectu document, which is almost, not too sure how many pages it is now. It's roughly probably about 100 pages or so. I think it's going for the Guinness Book of Records for, you know, how many pages we can put together for a back to work document. But it's colossal, very granular, but very detailed and very helpful. And I think that's been recognised by a lot of organisations, you know, certainly within, you know, the industry, that they've picked that up and they've used that. Not just in the UK. So we've had, you know, contact from unions and organisations outside of the UK who have asked if they could, you know, use some of the work that we've done on that document. So we have to say congratulations to, you know, everyone that did input into that, but in particular to the AD's branch and Jay Lasser, who did kick that document off in the beginning. So that's where we are with all the documents, and that's a brief history of where we're up to. They are, I would say, they're living documents. So they are amending those documents as the government changes the guidance. So every time the government makes an announcement, so whether it's about social distancing or anything else, they're having to update those guidance. So they've just done that just recently across the board, the broadcasters one, the BFC one as well. And also they do invite, if there is anything that's wrong in the document, that is factually incorrect, that we can go back. And we've done that a couple of times, particularly with the BFC document, where we've amended it a couple of times or requested it to be amended, and it has been amended. So they are living documents, which is good. And I think that's what we were quite keen on, you know, from like right from the beginning. We didn't want to see the back to work document that was just parked and static, because the industry is moving, and it's moving at a faster pace than we anticipated. And the government guidance is moving at a faster pace than, you know, we anticipated. So that needs to keep up with that. And equally, we need to make sure that we keep up with it as well. So that's where we are, Paul, in terms of all the back to work documents.
Thanks very much, Spencer. I'm just getting some messages in the chat saying that the link that we've sent out to the documents isn't working. We'll work to get a new link posted in as soon as I can. Okay, thanks, Spencer. Yes, we have one other aspect to this as well, which is we have also, independently of that work that Spencer's been doing with the BFC and with the sort of scripted area, so, you know, TV drama, major motion picture, commercials, that sort of area. We've also done a separate and quite substantial document on factual entertainment and outside broadcasting, safe working. And that document is also available under the industry-specific guidance pages on the Bectu website. And that covers, you know, it covers everything from outside broadcasting to, you know, the shiny floor stuff and documentaries and programs like that. So that's something that's additional. We've had information today that insurers are telling productions that that they will have less to worry about in terms of their liability if they're following the guidance. The industry guidance has been circulated, and insurers are very specifically circulating the Bectu guidance. They're circulating the Bectu documents and the BFC document. So, you know, it's something to really pass on to your members, to your colleagues, that when you start work, make sure that your employers are aware of those documents, because they do look after your interests, but also employers will have less to worry about if they follow that guidance. So it's a win-win for Bectu members and for employers, that if they follow the guidance that you as members have helped us pull together, then they're less likely to have liability. They're more likely to be able to go back to work safely. And as long as they stick to those guidelines, and that's the important thing, that they stick to them, it would be, it's in everybody's interests. There is an additional document as well on there that deals very specifically with outside broadcasting. Our factual entertainment and outside broadcasting document does it broadly, but there's something that's much more distilled and focused just on OB that's also available on the Bectu website. Okay, and lastly, I'd urge everybody to get in touch with their branches as well, because every branch has been doing work on sector-specific bits of safe working guidance. I know that, I mean, there's been an amazing amount of work that's been done by our branches, like the hair and makeup department in particular, and the costume and wardrobe department, who've been doing a lot. And of course, they have very specific challenges around social distancing. So do keep in touch with your branches and look for any guidance that they're sending. There's really some spectacular work that's gone on. The Canberra branch have been working on reporting mechanisms and things like that. Okay, so what I'd like to do now is move on to the main body of the meeting, the important stuff, which is the terms and conditions. Before we talk about the Bectu terms and conditions document that's been circulated, there are two big issues that have been coming up recently. The first one is on intrusive questionnaires. And you'll see that there is a bit of guidance that we've provided. We're seeing some horrendous things. We're seeing questionnaires that are asking people about, you know, are you pregnant, about menstruation, about sexually transmitted diseases, things like that. Really, things that are OTT. Now, we have had members tell us that they've had those questionnaires before the COVID-19 thing struck up as well. But we're worried that there will be more of them. And we'd urge everybody to read that briefing. And I don't know if Spencer or Marion, if you want to say a few words, if you've got anything to add on that issue.
Well, Paul, let me just come in briefly on this. I mean, I think the stuff on intrusive health questionnaires is really important, and you'll all have seen the briefing. But a lot of this does depend on employment status in terms of your legal rights. So you'll see in the briefing that we've talked about potentially arguments around disability discrimination, sex discrimination, and so on. And that could well be a way of challenging some of this, but more importantly than just challenging the fact that you're being asked for this intrusive information, it's about what happens if you're actually refused work on the basis of those questionnaires. And that's really where the equality law protections come in. Paul, I don't know whether you want me to talk about the freelance employment status now or come back to that after terms and conditions.
I think if we could do that, actually, why don't we do that just before we get on to the terms and conditions? Let's cover off the intrusive questionnaires thing. I think it's important that people understand that issue before we get on to generally, you know, what employment rights or what can you enforce? Because as a union, we enforce some things using our, you know, we take legal advice, we challenge employers on legal grounds, but often we just challenge them on moral grounds as well. We often say to employers, you know, do you really want to be an employer that has a reputation for treating people in this particular way? And that also helps us. But yeah, let's come on to that. There's one other thing in that briefing that I'd urge people to look at. I mean, I think there are two big issues that we have with the intrusive questionnaires, aside from the fact that they're, you know, it's a shockingly tasteless thing to do to send someone something asking them about the size of their prostate gland or whether they've had, you know, whether they've had a sexually transmitted disease. There's the question that Marion has outlined, which is that it may form the basis of unfairness if you know, if essentially they're sending out questionnaires that are more likely to expose women to losing their jobs, or not being offered work in the first place. But then there's the second issue of what happens if you fill out this questionnaire and then the you know, the people managing the questionnaire contact the production and say, you know, don't employ this person. That for us is very worrying, and particularly given some of the questions that are on there. So, you know, you can imagine all sorts of hairs will be set racing where employers are thinking, well, I wonder, you know, was it the STDs bit, or oh, we didn't know that so and so was pregnant, or something like that, you know. So there is and that's the sort of very prosaic thing. But in real terms, that is a GDPR breach. That is, you know, if the employers have got to be very careful about how they get this information off you, how they store it, and how they, pass on pass on conclusions that they've drawn as a result of it. Okay. So the second issue we'd like to raise before we go into the document is the issue of the avoiding or transferring liabilities onto workers. And we've had two very specific issues raised with us by our members. The first one is that employers are asking workers to accept liability for some of the damage to equipment or cars hired by production. And what they're doing is they're saying, well, if you damage a car or damage your equipment, you'll agree to pay the first, it might be £750 of costs. And that allows them to reduce their insurance costs. As anyone who's ever bought insurance knows that the way to reduce your costs is to increase the excess. So when you hire a car, when you go on holiday, if you increase the excess, if you say I'll pay for the first 500 quid's worth of damage, then the insurance comes a lot cheaper. So what employers are doing in a very naked way is they're saying, we want you as our workers to take risks off us, to incur costs or incur potential costs to reduce the potential costs that we have. The second one is that we are having employers asking workers to waive employer liabilities. I've even seen a contract that said, in signing this contract, you agree that if you suffer from any illness or injury as a result of working for us, that you'll essentially give us a waiver of liability. So Marion or Spencer, would you like to come in on what our approach to all of that would be?
Can I just pick up just briefly, Paul, just on the intrusive, questionnaire? Because I think we need to spell out and make it clear that those questionnaires shouldn't be sent before the job offers, been made and accepted, because that's crucial. So if they're sending it to you before to try and, weed out certain individuals to find out, whether they have got, certain conditions, then that is potentially discriminatory, so automatically. So we need to make sure that it's happening in the right order. So if you're being offered a job at that point and you've accepted that job, then at that point they can actually issue, the questionnaire. They can't do it beforehand. They can't say, look, want to find out your availability, and by the way, we want to send you this, questionnaire. So we need to make that really clear. The second thing is, I think we probably need to ask some questions about, these questionnaires to the insurance companies as well, because I'm not clear about, why they need to know, certain things about certain, genders, because I'm not too sure what impact that has on, their employment. So I think we need to ask those questions, because I think they just might have been there, for a very long time, and no one's actually, reviewed them. So I think we need to challenge and find out why, they are actually, in the original, questionnaire. And I think we also need to make sure that, people, members let us know, if they are getting these questionnaires, to feed them into the union, because we need to know if it's just happening on, certain productions, or it's happening across the board, or, so we just need an idea so we can map, where it's happening and, how often it's happening. So that'd be really useful. And I think, if they're doing it for the purposes of making, reasonable adjustments, so they're identifying if someone has got, some, protected characteristic or some disability that they want to make reasonable adjustments, I think that's a fair call. I think they should, they should be trying to do all they can to try and make those reasonable adjustments so that individual can, return to work and return to work safely. However, I think they're doing it for different reasons. And I think we need to, find out what those reasons are, because I can't figure out why they're asking certain questions and what that has, anything to do in terms of them actually undertaking, their work on a daily basis. So I think we need to go back and talk to, the insurers on that. So that's all I wanted to say on that particular point, Paul.
Thanks very much, Spencer. Okay. And on the liabilities question, Spencer, on the transfer of liabilities onto workers.
Yeah, I don't think so. I've seen some, a form of words in contracts where they've said that, you can't make a PI claim, in the event that you, suffer an accident or injury or even, death. And I don't think they can actually, put that in there. Marion would probably be, be able to, detail that a bit better than I can, but I don't believe that they can actually absolve themselves of any, legal responsibility to say that someone, can't bring a PI claim. I think it's about, we know that it's about proving negligence. So if an employer, has a duty of care and they don't, follow, whether it's the guidance or whether it might be, and they've breached their duty of care, then that's the basis on which someone can actually bring a claim. So I think it's kind of redundant, those clauses in the contract. But I think we need to remind people that, if we do see those in there, they should inform the union. And if anything, what they can do is actually put a line for it. So they're saying to the production company, they recognise that that is, that waiving your rights to a PI claim is, is not right. And, they've taken advice on it. So all you need to do is put a line for it, initial it. The rest of the contract still stands, but that particular clause doesn't.
Thanks. Marion?
Well, just on that last point, I think actually Spencer said it all. You can't contract out of personal injury rights. So an employer can't just write into a contract to say that you absolve us of any potential claims. And particularly what we've been seeing lately is employers trying to avoid any liability for COVID-19 related injuries or illnesses. And again, they simply can't blanketly exclude themselves from those liabilities. And the thing with personal injury is that you're always talking about what the employer has done to mitigate any risk. And that's going to be very much a fact sensitive government guidance, Bectu guidance, industry guidance. The safer they are against resisting claims for negligence. But where they're not following that guidance, and unfortunately across all sectors we've seen lots of areas where that hasn't been complied with, that's when they're really at liability. And whatever your employment status, and I'll come back to the issue about employment status at some stage, I'm sure, but anybody working for somebody else will be covered by those minimal rights about health and safety, and will be able to bring claims for negligence if employer breaches those provisions.
Thanks, Marion. Okay. I think now is the time, Marion, for you to for you to outline, before we get on to the details, because I think we've covered everything else now. We've done all of the prelude that we need to do on the discussion of what our views on terms and conditions are. I think now would be the time for you to just outline the different forms of enforceability that we have. So, the difference between, if you're employed as someone who's on a full-time job, PAYE, if you're employed through Schedule D, or if you're employed through a limited company, that you do have different employee rights, and you have different enforcement mechanisms available to you.
Okay, this is a massive subject. So I'm just going to try and sort of cover some of the basics on this very quickly. I think firstly, as Paul just said, rights at work are dependent on your employment status. And there's basically 3 different types of workers that could be in the workplace. So firstly, you've got the genuinely self-employed, and that will usually, though not necessarily, include everybody working through their own limited company. It can also include other people that haven't set up as a limited company. But if you're really genuinely self-employed, then your only rights are going to be rights under contract, which is why it's so important to agree good terms, conditions at the start of taking up an engagement. And then, as we just mentioned, health and safety and personal injury rights. So you've got those as self-employed people. I think one of the problems for freelance workers is that they're often told that they're self-employed and they have no other protections, when really in law they do have a lot more protection than that. And we've seen many cases over the years of challenging that issue around employment status. So self-employed is the first category. The other 2 categories, workers and employees. So employee clearly has the full range of statutory employment rights, but unfair dismissal, redundancy and so on. And that will be people that are clearly employed under a contract of employment. But there is this growing group in the middle called workers, and they will have rights under the Equality Act. So rights in terms of discriminatory decisions about offering them work, dismissals, rights against harassment at work. So all those Equality Act provisions under the protected characteristics of sex and race, disability, sexual orientation, age, and so on. And they'll also have working time rights, so limits on hours, rights to paid holiday. Paul, that are under a contract, but not necessarily a contract of employment, but undertake to perform work personally for the other party. So there's a range of tests. And again, I think it's often commonly misunderstood that it depends on your tax position. But really, whether you're PAYE or whether you're paying tax separately, you could still be classed as a worker, because the tax and national insurance position is only part of a range of factors. And the most important factors are whether we can argue that there's mutuality of obligations. So you're obliged to do the work, the employer's obliged to pay you. That's one of the key tests. And the other one is about whether you can send a substitute in to do your work. And that all sounds a bit crazy. But if you're working in a role where you personally commit to doing the work, much more likely to be held to be a worker or an employee. So I think really freelance workers shouldn't just take this mantra from employers that they're all self-employed and they haven't got any rights, because actually very often they do. We had 2 cases for Bectu freelance members last year where we brought tribunal claims, and we successfully argued that they were actually employees. So they had the whole range of rights, one getting a redundancy pay and another one getting rights in terms of being subjected to a detriment. So lots of rights that people have, lots of challenges on these. And I think the difficulty in terms of talking about it in this sort of scenario, there isn't one size fits all. Lots and lots of case law. You've probably heard that the case of the Uber drivers was in the Supreme Court this week. And while that may seem a million miles away from the sort of work and the employment situation that you're all in, it's actually legally incredibly significant about those decisions about who a worker is, who an employee is, and those tests really important, and that Supreme Court judgment's going to be very eagerly weighted. But as I say, we've got lots of examples of freelancers where we've successfully fought the position. I'm actually working on 2 more Bectu cases today that we've got to get in to the employment tribunal by the end of today. So there are lots of rights. So I think just think about that, and think particularly about equality aspects, as we talked about in terms of the intrusive questionnaires, but also things like whistleblowing, rights to raise health and safety detriments, and so on. So let's see where we get to perhaps in the Q&A with any more discussion around that.
Thanks, Marion. I mean, it's in a way, you know, one of the issues around freelance working is that ultimately so many of the rights depend on whether you're prepared to sign up to the contract in the contract of employment in the first place. And unfortunately, often one of the ways of enforcing your own rights is to refuse to carry on with the job, is to leave the job, which, you know, it certainly isn't ideal. And we're in a very strange situation at the moment where the government seem to be saying to a lot of people who work under the freelance umbrella that, you know, you've got lots of job security, you don't need government assistance. And I think, you know, so many people who are freelancers and have worked as freelancers for years know what a cliff edge that they're looking over all the time. Okay, so I think now we can move on to what I think the main course of the meeting is, which is the document that's been circulated on terms and conditions, the terms and conditions guidance document. And you'll see, if you haven't got it already, in the chat there is a WeTransfer link. I know that one of the links that went up wasn't working, but someone else has posted a better one today. So we're going to go through that now. Spencer, do you want to pick this up, because this is a document. It's 2.5 pages long. It was thrashed out over a meeting that lasted a couple of hours back in early June, I think. So it outlines what our advice and position is on a range of issues. Spencer.
Yeah, thanks, Paul. I'll just touch on the key points rather than go through it,
Yes, of course.
line by line. So I'll just do the highlights. So just to reiterate the point that we made before about the job offers. So before they send you any of these questionnaires or any of the other documentation, make sure that you have actually agreed and accepted the job. And I noticed someone posted it up on there, which is true, that not everyone gets contracts, and sometimes you get the contracts right at the end, or a long time after the production is actually finished. So it's crucial that people get something in writing. Really, really crucial, because we get lots of situations where people say, they were offered a job, they accepted the job, but then, for some spurious reason, the employer or the person who, made the offer decides something else. So it's useful to put something in writing to whoever made the offer, to outline just the basics in terms of, when you're going to start, how much you're going to earn, and those sorts of things, just so you've nailed that down. And only once that's been agreed that they can then send you all the documentation in terms of the questionnaires and those sorts of things. And also it's worth underlining the issue about the duty of care of the employer. It's the duty of care from the employer. We need to make sure that we say that all the time. They have the duty of care to make sure that you're safe when you do go back to work. That is ultimately their responsibility. So that covers those two things in terms of responding to the job offers and the questionnaires. In terms of compensation for loss of employment, so we've had certain situations just recently where I know on one production they turned up and they're doing the tests, the thermometer tests, the gun test, and two of them were over the temperature. And normally, production would release them, let them go home, and they're not under an obligation then to continue to pay them if they're not working for the production. They didn't. They chose to wait a few hours. They tested them again, and they were fine, and they continued. However, we're going to probably see more cases of this, and whoever employers are risk adverse and want to send individuals home as soon as they've tested that they are above the recommended temperature. In those circumstances, most employers, what we're hearing is that they're going to release them and they're not going to compensate them. Our very clear view is that people should be compensated. They should be paid, because what we don't want is a situation where people could they could have COVID, but they still need to work. They still need to earn an income, and they come back too early. And if they come back too early, then that runs a risk to the rest of the crew. So we need to put a mechanism in place, and we need to get the employers to recognise that they have a duty to make sure those people are compensated, so they don't come back, and they don't come back too early. So if they need to self-isolate, they should be compensated for that period. So we need to make sure that PACT and the rest of the employers know that, and know that's our position. And I think in the interest of the industry and making sure it operates effectively, that's got to be one of the considerations. Just looking through, just in terms of the other changes to terms and conditions, we just need to monitor to make sure. So we've got various agreements. We've got the major motion picture agreement, we've got the TV drama agreement, the construction agreement, and the APA guidelines. We need to make sure, and we've had good signals from all the employers that certainly from the panel discussion we had the other week, from the major motion pictures and the high-end TV, that they're not looking to vary or amend or change the terms and conditions to any detriment, which is great. However, there are certain productions, and we've seen it already, certainly within commercials, where they're making changes to certain people's contracts. And so we need to be made aware of that so we can challenge those productions. I'm not suggesting that we're going to be able to turn things around, but we can't do anything if we don't know what's going on. So we need that early intelligence in terms of what productions are doing so that we can respond to that. The other thing on your list, Paul, was about, you know, working hours, and that's really that's a really important point, because we all know the working hours in this industry are excessive. You know, I've never heard of anyone saying, you know what, I've got all this spare time and I don't know what to do with it. So we need to make sure, particularly now where there's all these new restrictions and all these new things that you need to put in place, that we don't see these long hours. So on top of what you're already doing. So we've already made it clear to the employers, they need to factor these things into the actual time that you're working. And we need to all send that message. We all need to send the message back to productions that it's in their interest as well. Because if you're fatigued or if you're tired, you're going to make mistakes. And if you make mistakes, that's going to not only be bad for you, it's going to be bad for the production as well. So we need to make sure the production hears it, not just from the union, but from everyone as well who's been offered a job. So we need to make sure that message does get back loud and clear, you know, to productions. Just looking at what else there is.
Just before you move on from that one, Spencer, there's just one observation as well, that I know that a lot of productions that are working away from the recognised bases. So, you know, once you're out of London, some of the productions that are happening all over the UK. So if they're working in very remote locations, we're also picking up that employers are saying, well, because of social distancing, the amount of resident locations available to us are fewer. So we're getting production saying, normally we would put you up in a hotel, but the availability of hotel rooms in the locality is a lot lower because of social distancing. So they're expecting people to drive a lot further in the mornings. And, you know, I'm advising members to ask for travel under these circumstances to be included in the working day. You know, we are asking people to only work their contracted hours, so not to, I think there's a situation where you're having to work an 11-hour day, really concentrating on social distancing. There's an awful lot more work involved, all the additional cleaning involved, to then be expected to work a few hours either side and then travel 2 or 3 hours on top of it. You know, it's crazy. And I was speaking to a makeup artist only the other day who was saying, once I'm exhausted, I'm going to forget to put my mask on. I'm going to forget to do some of the social distancing measures I should be doing. So I think these are arguments that we should be putting to employers. Sorry to interrupt you with that, Spencer, but I didn't want to lose that, because it's an important bit of feedback we've had from members.
Yeah, no, it's really important, because all of those things we need to factor in: the travel time, you know, the additional prep and wrap, you know, that they tag on, you know, to the beginning and the end of the working day. All of those, you know, do increase, you know, the working hours. And it was always our ambition, you know, that we want to, you know, tackle, you know, excessive working hours. And I think it's become, you know, more apparent now that we need to do that, you know, we need to do that urgently. And it's an opportunity for us as well. And it's an opportunity for the productions to work better and work more smartly in terms of the way they're doing, you know, they're asking people to do these hours. So, you know, we're certainly having those conversations, and I know they were, you know, talking about maybe split shifts and, you know, some of the production staff, you know, working from home and, you know, just working differently and thinking about how they can make the production fit together, but not increase, you know, the working hours. And I know one production in particular has said, you know, from I think they're starting in September or October, they're not going to have any overtime. You know, they've scheduled it, so they're not going to do any overtime, which I think is, you know, commendable. And the thing is, we need good examples, you know, so if we've got those good examples, we can show other employers, this is the way you should be doing it. And if they can see that they've done it effectively and productively, and they've got, you know, what they wanted, you know, at the end of the schedule, then, you know, that'd be a good example that we can, you know, share with everyone. I think I've probably covered everything, actually, Paul, in the document you've produced. There was the working, you know, from home and, you know, working away, which I think we've probably touched on, actually, and dealt with.
Yes, I noticed there's also the stuff on safe working advice and representation, where we've got. I noticed that I haven't put the email. I should have put the email on that, and I've just realised that this is a slightly out of date version of the document. It should have the email, which is covid19@bectu.org.uk, and we are going to be looking at. I mean, at the moment, some branches are doing reporting. I think we need to have a conversation amongst our branches, and this is answering Catherine's question in the the Q&A. I think we need to have a conversation with our branches about reporting, because I think sometimes different branches will want different stuff reporting to them, and I think it's important we do stuff through the branches rather than do it centrally. I think it means we end up representing people a lot more effectively if we go through the branches. And I think Spencer's point there, what we want, and actually this is an appeal that we ought to be putting into this call, is when you find productions doing good things, we need to know about it. Because at the moment, as a union, the only thing we ever hear is when productions aren't doing the right thing. Of course, no one ever phones us up to say, you know what, this production, what they're doing is they're working a 10-hour day, they're not working any overtime, they're going to give us, they're making sure that they're going around making sure that we take our breaks, and they're doing social distancing really well. There's nothing like peer pressure that helps us, encourage employers to behave well. So we want our members to catch employers being good as well as catching being bad if we can. Okay, let's move on. So we've got the questions, we've got the Q&A. I'm going to put them to our expert panel. We've got a question from Claire about, does the safety document relate to backstage theatre work? Because there are a lot of Bectu members who work solely in theatre. Spencer, do you want to pick that up?
Yeah, sadly, all the documents that we talked about only cover the film and TV sector. It was set up, all the task forces were set up by the BFI, the British Film Institute, and were under the umbrella of the DCMS. So unfortunately, the ones that we've been involved in and the ones I talked about just cover the film and TV sector. I suspect there are, return to work documents for theatres and live events, but I'm just not across those because it's another division altogether.
Yeah, Claire, this event was set up and marketed primarily to London Production Division and Regional Production Division. It is very specifically about the return to work for freelancers working in film and TV. But I think that our Arts and Entertainments Division will be able to answer the question about backstage theatre work. And there are safety. I know that there is work been going on. Although I know, of course, the theatre industry is much more focused on is much more worried than we are in film and TV, even about the possibility of just not opening at all. That's such a big issue at the moment. Alex is asking about what protections do we have against intrusive questionnaires when employed on a loan out through our own companies. I'd like to, I'm going to throw that open to Spencer and Marion, but there's one additional point of information that I ought to point out from Louise, who's sent it me in the chat, is that if you look at the factual entertainment and outside broadcasting live working documents, safe working documents, you'll see that we have a model questionnaire that a number of employers and a number of employers groups have been circulating, and that doesn't ask any questions. That asks the bare minimum, and it's the questions that people should be asked every day. Is a member of your family ill? Have you got any symptoms? Of course, we really want everybody to make sure that they're being asked that every day before they go to work, just so that we can ensure safe working. So if you have a look at the factual entertainment and outside broadcasting document, Appendix 1, it's the last page or the last couple of pages in that, there is a model questionnaire. And I would urge members that if you're sent an intrusive questionnaire, send that back to them and say, look, these are reasonable questions to ask me. It's not reasonable to ask me about pregnancy and about menstrual cycles and things like that. But it is okay to talk about, it is okay to ask me questions about, am I ill at the moment? Do I have is there an illness there? But on the limited companies, what do we think?
Well, I mean, I do think this again comes back to the employment status issue, that if you're genuinely self-employed, then none of the Equality Act provisions will apply to you, so you have very limited options. But again, though, as I said, just the very fact that you're working through your own limited company doesn't mean that you're not a worker. So it is all very individual and fact specific. And I should have mentioned that there is a guide on the Bectu website called Members Guide to Atypical Working, which covers a lot of these tests in more detail. including a questionnaire you can use. So you can sort of see for yourself where you think you fall. So I think there's sort of two angles to this. Firstly, we think the questionnaires are overly intrusive, unreasonable, unnecessary, and people can take that up. But the second side of that is whether there's any legal response that they can make, and that really only applies if you've got those employment protection rights.
Yes.
Sorry, Alex, that wasn't a very good answer. It's a bit of a, well, it depends really.
Alex, it comes back. Alex, it comes back to the thing that, and I know you and I have had conversations about this before. It comes back to it's the same old question: is yes, you can take anything that you don't like, you can take up with your employer, but in this case, your employer is you. You can definitely raise your objection to Alex Unlimited. But that's another matter. I know it's not the sort of answer you'd want to hear, but it is the case. We've got a question about is the advice to refuse to answer intrusive questionnaires?
Well, I think that might be one more for you two, who are much more aware of the responses in the industry. From a purely contractual point, though, if you're looking for work and you don't comply with what the employer is asking you, you probably just won't get anything. So I think it's really about how you deal with it. And I think Spencer was saying, it's not a matter of just say no, but say, well, I don't think this question are fair, but answer the ones that you do. So you're not necessarily just giving a blanket, no, I'm not going to respond, because I think we'll all know what the answer from the company might be on that. I don't know whether Spencer or Paul want to add to that in terms of practical answers.
The only other point I'd probably make is that if everyone's going to be on that production, if you've got the the questionnaire, everyone's going to get the questionnaire. So it's about being part of a trade union is about collective strength, and everyone's saying the same thing at the same time. So I'd encourage, if you do speak to the other crew members, is to encourage them not to, if that's the position you want to do, is for everyone not to sign it or make amendments on the because then they can't single you out, because everyone's doing it, at the same time. And that will have much more of an impact than just you saying, well, actually, I don't agree with this, so therefore I'm not going to sign it, because they can actually, replace one individual, but they can't replace the entire crew. It'd be, virtually impossible. So talk to as many people as you can, get them on side. If they agree with you, then take that collective approach.
Thanks, Spencer. And remember, the thing that Spencer said right at the start is they shouldn't be asking these questions until they've made an offer of work. So on the issue of, well, if you don't sign it, are you going to have are you going to lose the work? You should have an offer of work already. And I think at that point, the point would be to say, look, Bectu there is a model questionnaire that's been asked throughout the industry. I'd urge you as an employer to be asking these questions, not these highly intrusive ones. I mean, to answer one of the questions that's come up in the Q&A, people are saying, someone has asked, why do they need to ask these questions? Now, as far as we can see, these questionnaires are coming from insurers and not from the actual production. So if you look in the, I don't want to go into too much detail. If you look in the intrusive questionnaires guidance, we've got something on that, because there are all sorts of data protection issues there that we'd be concerned about. But it seems to be about limiting liability rather than the stuff we've seen. The really intrusive stuff seems to be coming from insurers and not from the employers themselves. So again, by all means, pass it forward, but don't, they shouldn't be sending it you until they've made you the job offer. And if they are sending it you before they make a job offer, then that's likely to, we could argue that that's giving rise to discrimination. And I think employers should know that. They should be told that they shouldn't be asking those questions until they've made an offer of work to you. And if someone does, then advise them that. Say, look, I'm happy to fill out a questionnaire once I've had an offer of work, but not before. Okay. Someone's saying, do we have a right to refuse to fill out those intrusive questionnaires? I mean, I think we've kind of answered that already, Nick. I think you certainly should offer an alternative, and I would say the one that's in our factual entertainment and outside broadcasting, the appendix there. We've got Leah asking, this is an interesting one. Leah's saying, would it be better for employers to ask the employees for information relevant to reasonable adjustments after an offer of a job, rather than sending out a questionnaire to everyone?
Who do you want to answer that, Paul?
Either of you is the real issue that they should be asking what reasonable adjustments you're asking. I think as a union we agree that the more often employers are asking you, have you got the symptoms? Is someone in your family? Have you been in contact with the symptoms? We definitely want employers to be taking as many measures as possible to make sure that people who are likely to be unwell as a result of coronavirus to not be at work, and we want them to be paid if they're asked to leave the set. But I think anything else, I would say I'd kind of agree with that. That really the only other thing this question that people should be asking is, what reasonable is there anything we need to do to help you to be able to do your job?
I think there's a difference, though, isn't there, between what the production are actually asking and what their responsibilities are to the crew, and what the insurance company are asking and what they believe in terms of the scope of their insurance. So I think there's a difference. So the employer ultimately should be, making sure that they are they are doing reasonable adjustments, asking the right questions, and doing all they can to put those things in place. The insurance company is coming from a completely different perspective. They want to look at in terms of their liabilities. So that's why they're asking certain questions. I don't know. I haven't got a clue why they're asking, all those questions. I can understand certain parts of it, but there's a large part of it I just haven't got, a clue why they, need to know that, level of detail. So I think there is a difference, and I think the one I'm more concerned about is the insurers rather than the actual production, because I think we can have those conversations with productions and try and encourage them to do the right thing by people, because let's face it, diversity, which includes, people with, disabilities, entering the industry, is critical at the moment. If they want a thriving industry, then they've got to make those adjustments and get people, back to work and get back to work, safely. So, yeah, they should be asking those sorts of questions. But the insurers one is the one that really, I think we need to try and tackle, because that's really where they're coming at, they're asking all these questions really that should I don't believe should be being asked of crew.
Yeah, thanks, Spencer. Okay, we've got a question here, and I think we've sort of answered this from Nana, about, do creatives have to sign a COVID-19 liability waiver? Now, we've talked about liability waivers already. So if you've got a production who is saying to you that you're helping them to waive liabilities related to any personal injuries, or anything to do with gross negligence on their part, then they just can't do it, and you should cross them out. But so Nana, if you want to ask, I sense that your question might be slightly different. You're saying, do creatives have to sign a COVID-19 liability waiver? I'd be interested to know if the liability you're talking about is to do with health and personal injury, or is it some kind of professional indemnity that you're talking about? Where, because I'm worried about this word creatives. It suggests to me that maybe people have been asked to sign indemnity liability waivers if they fail to deliver some particular creative output. So I'm going to sort of skip on from that. But if Nana, if you want to post a follow-up question, please do. Just to reply, I've seen Rebecca's asking the industry standard model questionnaire. Rebecca, if you look on the page that has our safe working documents, you'll see there's a relatively new one on factual entertainment and outside broadcasting. And if you look at Appendix 1 of that, you'll find it in there. Catherine, good question from Catherine here. Spencer, what advice do you normally give on this? A lot of contracts are now issued online, so it's difficult for individuals to cross out specific sections. What would your advice be on this?
I'd say you need to send a covering letter back with it, just on the points where you've identified that you're not happy. So you haven't just accepted it, because I think if you send it back signed, then you've accepted all the terms that's in there. You can raise it by doing that. I'd always try and suggest, though, you have a conversation with whoever, you know, sent the contract, first of all, just to let them know that that's what you're intending to do. Because there might be another way of dealing with it. There might be a better way of dealing with it. But do that, first of all, and then ultimately I'd follow it up in writing with, you know, the contract that's sent back, just highlighting the parts where you want to amend or change or take out.
Thanks very much, Spencer. I mean, you know, there's always the little concerns that a lot of these contracts do have whole agreement clauses in them that say that, you know, that this agreement is. I mean, Marion, what do you think about this? So if I send you a contract and ask you to sign it, and it's in an electronic form, I'm putting you on the spot now. So it's in an electronic format, and one of the clauses is that this is a whole agreement. So one of these things that says, you know, in signing this agreement, I accept that there aren't any side letters. You know, what's the? You may reply to me that there isn't a correct answer to this.
Well, I think it depends on the status at which you're raising those objections, because it can only be a whole agreement once it's been agreed. So if you're writing back to them saying, I'm not happy about X, Y, and Z, rather than saying, actually, I'm getting messages telling me my internet connection is unstable, so I'm not sure whether you can still hear me or not. You can. Okay, so I think it depends at the point, but really it's a matter of raising it as a side issue and not agreeing the contract until you've actually got those things ironed out.
Yes, and Mark has pointed out in the chat as well, I think it's Mark, so someone's pointed out in the chat that, of course, no, it's not Mark, it's someone else, is that you can print contracts off. And you know that might be a route where you print them off, you cross it through, and you initial it. Okay, let's move on. We've got a question. Thanks for that, Marion. We've got a question now about car damage. What about the car damage deductible that we were discussing? That is this issue where someone's been asked to essentially sign something that says we will, you know, we will pay the first £750 or £500 worth of damage on the car that the production are. Spencer, what do you think?
I think that's an automatic line through the clause, isn't it, to say that you're not going to agree to something like that, because you're giving them your credit card, aren't you, by agreeing to something like that. So we all know what it's like, the smallest scratch, you know, whatever it might be, that, you know, you're going to be in for, you know, covering that liability. I'm not sure whether the production can transfer liability. I suspect they probably can, if you agree it in the contract. But my advice would be that they should scrub that out immediately, because you're leaving yourself wide open, like I said, handing over your credit card to the production and giving them, you know, access to your account.
Yeah, I mean, I think that they'd be more likely to try it if they're employing someone who's trading through a limited company as well. So you can see where they do that. But I think Spencer's right. Really robust response. Bottom line, don't accept it. We'd urge you not to accept it. Okay, we've got something. This is something that comes up time and again. We've got someone talking about how in film and TV drama the contract's only given to crew during the shoot or towards the end of the shoot. In that case, if there's a clause in the contract, the employer puts a line through it and doesn't accept the amendment, where does the employee stand? As many productions refuse to pay the last 2 weeks' wages until a contract has been signed. You've got a lot of experience of this, Spencer.
Yeah, it's a separate issue, so they can't withhold your money, because, you know, providing you've discharged your duties competently within you know, the contract, you know, you need to be paid and remunerated for those monies. So we do get it quite a lot, you know, where productions are saying sign this, do that, or, you know, some other aspects of it. Particularly when it's not even written into, you know, the contract that, you know, they can withhold those monies. So I always say to productions, look, you know, there is a legal route in terms of, you know, recovering your last 2 weeks. But I always say to them, this is a classic, you know, money's owed. If they're refusing to pay, and in those circumstances where we've got money's owed cases, we put them in the magazine for failing to honour their obligations to our members. And this is one of them. And that normally has quite a good effect, because there's not many production companies that want to end up in an ask first list. So that normally, funny enough, focuses their mind, and we normally come to some sort of agreement on it. So I'd suggest if you are faced with those situations, contact the union. We can try and get involved. And, you know, we've got numerous cases where we've managed to unpick those particular problems.
And it is completely unreasonable for an employer to do that. Sorry, Marion, I interrupted you there.
Oh, I was just going to say that contractually, you've got a contract, even though it isn't written down. So from the day you agree to do the job, they agree to pay you. You've got a legally binding contract. So if they're then issuing the contract towards a written contract towards the end of the job, then that's a variation of contract that you don't necessarily have to agree to. So, you know, I completely agree with Spencer. You've already got a contractual right to be paid for those last 2 weeks. But just remember that a contract, although it's best to have it all set out in writing, it doesn't have to be legally binding. And the fact you've agreed the terms of the job verbally will be contractually binding on both sides.
Thanks, Marion. And there are two developments to bear in mind on that. There's one that's a sort of, we could say, is a Bectu development, is that, you know, we recognise that there was a huge problem with this issue of people being asked to sign contracts closer to the end of a contract than the start of it. And what we agreed on both the TV drama and major motion picture agreements is that once you're employed under those arrangements, you already have a contract of employment, and any subsequent contract you sign shouldn't have any detriment to the one that you've signed. So if someone phones you up and asks you to start work next week on a TV drama under the Bectu Pact TV drama agreement, they'll send you a deal memo. And that deal memo, combined with the agreement, is a contract of employment until it's replaced by something that the employer asks you specifically to sign. They often will ask you to sign stuff that has, you know, copyright clauses, things that we don't concern ourselves with. And as long as that contract isn't detrimental to the one that you have through the agreement, then that's fine. So most of the time, if you're working on those agreements, you'll have something. We know that doesn't apply to low budget, but there's also some good news for people who are working on areas outside of the agreements, is that as of April this year, employers now have a legal obligation to give people a statement of particulars before they start work. And that's a change. That is a very specific change. And Tony Lennon has been doing briefings on this. But generally, if your employer asks you to work without giving a clear statement of particulars, you know, how much you're going to be paid, when you're expected to start, what sort of hours you're working, then we need to hear about that, and the employers need to be stopped from doing it. Okay, we've got someone asking, are freelancers such as SAs covered by any of these? If you're working through, particularly if you're working through an agency. Spencer, do you want to pick that up?
Yeah, thanks, Paul. Yeah, so supporting artists there is a section in the British Film Commission document that covers performers in there, and I believe, you know, the FAA did provide, you know, some wording to go in there. It doesn't matter whether you're contracted through they're an employment agency, they're not an employment business. So your employer is the production company, not the agency. In this particular, because you come under the conduct regulations in the entertainment sector, so you're still covered within the scope of the British Film Commission guidance. Have a look at it. It's online. You'll be able to have a look at the return to work documents on the Bectu website. You should find a section in there.
Dawn is saying, I'm not sure what you're saying here, Dawn. You're saying that the FAA Pact agreement, this has currently been negotiated, a nightmare, to be honest. I'm not sure what that means, but if you've got a question, Dawn, let us know. Okay, I've got another question here. I'm not quite sure what I've been asked. It's saying so about the temperature tests and being sent home if we fail it. Do we have to, or are Bectu saying to people that they should add it to our contracts? I think we're saying that, you know, we have a number of recommendations. I think we're urging people to press for to be paid for time that if they're sent home if you've got a temperature, or, you know, if you're asked to go home because of a COVID-19 thing, we're asking people to press for full pay in that. But I don't know if we're specifically asking people to add it to their contracts apart from adding that as a clause. I think one other measure we're saying is that it would be good for members to press for longer notice periods at this time, if you can. So that if a production comes to you and say, well, we are asking you to take 3 weeks off unpaid, if you've got a notice clause in it, you can say, okay, well, in that case, I'm handing in my notice now. And they would have to pay you for that notice period. So having a strong notice clause, this is my Barratt Room lawyer coming out, so I suspect Marianne and Spencer will probably tell me off for suggesting this. But I think putting a notice period, asking for a notice period, and asking it for it to be more than a week, because I know a week is kind of the industry standard, even if you're legally only allowed, if your statutory right is only to a notice period after you've been working for more than a month. But it might be worth asking very specifically at the start, saying, I would like a notice, I want a notice period in my contract, and I'd like that notice period to be longer than normal. What do you think to that? Is that something the employers are likely to swallow, Spencer and Marianne? You're on mute, Spencer. You're on mute again. You muted yourself.
There we go. Maybe it was the employers that were muting me, Paul.
Not that it won't be the first time.
In negotiations.
It won't be the first time they've tried it.
So the answer is probably no. The employers at the moment, it's difficult enough to squeeze a contract out of them, at the point of where, people actually start work. If people can argue for, better terms and conditions, including, a longer notice period, then great. Obviously, try and get that in there. But I can see the employers at the moment, they're going to resist, those sorts of changes. And I think, when I said at the beginning about at the moment, we want to make sure that they're adhering to all the agreements that we've got and making sure that they're not, varying those terms. So I think we need to monitor that first and make sure that they're not doing that, because there is evidence, there is some productions, particularly in the commercial sector, where they're choosing to, try and reduce the rates and, terms and conditions. So we want to make sure, even though we've had really good signals from the high-end TV and from the major motion pictures, that would never cross their mind, from the panel we had the other week. We still need to make sure that we, keep monitoring that throughout this period. Still argue for the better terms and conditions by all means, but I'm not sure that they're going to agree to them.
Okay. I'm going to skip through. We've got less than 50. We've got about 15 minutes now. We're going to end the call at 3:30. I know that some of the panelists have to be on other calls, but I'm going to whistle through some questions. We've got one here from someone who's a PAYE freelancer working for BBC Birmingham, works to a low rate, which this person is prepared to accept. However, there's no travel costs covered, which is a health risk. Is it going to be possible to argue for travel costs to be paid, or is doing so likely to result in him losing out on work?
Probably comes down to two things, doesn't it? One, how much they want you, and how much you want the job. That's what it's going to come down to. Unfortunately, it's going to come down to local negotiations about and the thing is, if you've got a relationship with that production at the BBC, then you might be able to try and agree that. Travel is one of the issues that's on our agenda just generally. We want to, reduce or get rid of, travel in any of the agreements that we've actually got. So it's one of the objectives that we certainly set ourselves in, when we get back to, renegotiating those agreements. In the meantime, there's no harm in asking. Ask the production, say that, you've got a long distance to go. Your rate is not, what you'd normally work for, and therefore, can they compensate you for that travel time?
Yeah. Konstantinos is asking about APA. People working on the APA agreement. That some productions are trying to underpay people in the first wave, post COVID promo productions, just because people are so desperate to take the work. I think our message back is the one we'd always give you, Konstantinos, is if you can organise people to stick together. If there's anything the union can do to help you do that, we're always willing to. We'll always take that call, and it's something that we will do wherever we can. Somebody else talking about additional hours, including prep and wrap. Our guidance is that during this period, people should only be working their contracted hours, and that But the fact is, employers can still do it. But I think there's a strong moral argument not to. The issue that we've had from that I've had from people telling me that working in this environment in social distancing and safe working is a lot harder. You've got to concentrate a lot longer. You start to make mistakes at the end of longer days. So anything you can do to push back on that. We're always urging our members to push back on the amount of prep and wrap they have written into their deal memos. So I'm just going through these. Someone saying, ask to quarantine in Ireland for 14 days. Should we therefore be paid for 14 days or just the 5-day week rate? I don't know what you think to that, Spencer.
Our view is, and I think we might have even put it in, one of the documents, is that, you should be, compensated. If they're requiring you to quarantine for that length of time, then, the production should bear those costs. I haven't seen any evidence of the production doing that yet, on any of the jobs that have slowly gone back, where they've required people to do that. But that's certainly, the union's position.
Okay. Louise is asking a question, which I think Louise can probably predict what our answer is already on this. Unscripted factual contracts tend to include waivers for working time regulations for production team. So there's no hours, no limit on the hours on this. I mean, Louise, obviously we're really against that. Anything we can do to we would like to get an agreement that covers unscripted and factual work in the way we've already succeeded in getting one on scripted. And I think particularly at the moment, you can opt out of the opt-out, but generally, if they put it in the contract that you sign, I think you have to wait. They can make you wait up to 3 months before you can opt out of that, the working time directive opt-out. If that's not I know I could have explained that better, but I hope everyone understands what I'm saying there. But absolutely, we think it's wrong. We would like to do anything. If you can get you and your colleagues in unscripted and factual to work with us, we're currently pressing to get people to be able to stick together more effectively. Anything we can do, that's the only way to change that, unfortunately. Okay, next one. Starting a contract soon with a company where they previously do not pay sick days. This is factual. It had to come out of your holiday pay. Will they legitimately be able to do the same thing if someone falls sick with COVID? Spencer, what do you think?
Yeah, they can, and particularly if there's nothing in your contract or you've got nothing in writing, so they don't have to compensate. This is nothing. We're seeing this magnified because of the COVID situation, but we have witnessed situations where freelancers have had to leave productions because they're not well in the past, and productions haven't paid them. And unfortunately, it's come down to not necessarily how good the production is, but what your relationship is with the production. When they have decided to pay people. What we're trying to encourage production is that, particularly now that we're in a crisis, with the situation we've got at the moment, they need to assist not just their own industry, but the whole economy and the National Health Service. So it's important, if someone is sick, that they should be compensating them. So what we said before is that they don't come back to work too soon, and therefore jeopardise the production and the safety of everyone there.
Good, thank you. Right, we've got some really good questions here. We've got one saying, so this is really interesting, right? So as a Schedule D or limited company shooting, producer director in this case, I think, working on a documentary, if we're asked to self-isolate as someone who may have filmed somebody else who turns out to have got the COVID symptoms. So if you're contacted by your employer or as a result of contact tracing and told you have to self-isolate because you've been in contact with someone through work, what are your rights in terms of pay?
Well, shall I just quickly say on this? I mean, in a pure contractual basis, it really will depend on what your contract says about times when you're not required to work. So if there's a clause that says, they can lay you off or stop you working for any period of time without any pay, then there's not much you can do about it. If you were an employee, of course, you'd have stronger rights. But I think it does depend on the contract, really. And again, it comes back to what you can negotiate about the contract before you start.
Thanks, Marion. So that's the, that's the legal situation. I think, this is where, I mean, I think as a union, we would want to draw attention to an employer who says, "Oh, we've put you in a situation where you have to self-isolate. So off you go home, and we're not going to pay you." I think that's something that I would very much like to call that employer and ask them if they're for real. But it's certainly something that they can do legally anyway. And another slightly, I think this is tangential to this. Can a production legally exclude you from working if you have a pre-existing condition that will potentially make you more vulnerable if infected with coronavirus, even if you're not actually infected? Marion?
Well, I think there's lots of examples of that across the union, really, where we've had to advise members in this case. And it does depend on whether or not we've got that Equality Act protection, because we've seen cases where people are being excluded because of their age or because of serious health conditions or because they're pregnant. And all those situations would be covered by the Equality Act, and we'd be looking at indirect discrimination because a greater proportion of one group wouldn't be able to apply. So what it then comes down to is whether the employer can justify their requirement. So it'd really be very fact specific on whether or not they could do that. But I do think, our starting point is going to be, well, actually, to put those sort of restrictions in place is going to potentially at least be indirectly discriminatory under the Equality Act. So if you fall within that worker definition, yeah, let us know, because there may well be cases there. And there's at least one already I know we're investigating in terms of putting in tribunal claims on the basis of somebody who's pregnant and being refused work because they're allegedly at greater risk of COVID-19.
And again, Marion, just repeating what Spencer said right at the top of the call, is they shouldn't be asking you these questions until you actually have a job offer. So certainly if they're asking the question beforehand, it doesn't really matter what the answers are. They're already behaving in a way that's likely to give rise to discrimination. Okay, thank you for that. I'm going to answer that one. And we've talked about, this is a good one, and this came up. As Spencer and I have had calls about exactly this issue already. We've got someone who's been asked to take on a role as a COVID-19 team supervisor. Is there any guidance on contracts and job descriptions for these roles? It's a lot of responsibility, and based on comments about accepting liability, will there be protection for people who do these jobs? Spencer, what do you think about that one?
I think our position is that, that these should be separate roles. So they shouldn't, first of all, they shouldn't just be, dumped on top of, your existing, job. Because as we know, just doing your existing job is tough enough in the environment that we're in, let alone taking on additional responsibilities. So they shouldn't be, requiring people just to take on this role. It should be a separate, identifiable, job. The thing is, providing if you're doing that job and you've had the necessary training, because there is the training that's out there, to do these jobs, that and you're following the protocols that we talked about, then the liability is still rests with the production, providing you've carried everything out and you've done everything as in accordance with the guidance, then you're protected. So I think that the key to it is make sure that if you do this role, make sure it is that's your only sole job, and that you've had the appropriate training, because then you have some background in terms of what's expected of you to do that particular job.
Yes, and we have heard reports of productions that have got into difficulties related to coronavirus, and it seems that the people who are responsible for them aren't always people who are particularly senior or authoritative on the crew. So the idea that you have somebody, if it's someone who's on a very low rate of pay, someone who doesn't have any status, it's very likely that social distancing rules won't be being supervised properly and won't be being managed with some sort of authority. So we don't have any specific guidance, but we've certainly heard the view that it should be someone who's a first or second AD doing it. I think that's I'm not going to put my head on the block by saying I agree or disagree with that one, but it is something that we've had put to us by members, and it's an interesting topic for discussion. Okay, but in terms of their liability, remember, if you're working for an employer, the ultimate liability rests with the employer. So if they appoint you as a COVID-19 supervisor, they have to take responsibility ultimately for, they're the ones who ultimately take the responsibility, and not you. Okay, I'm going to whistle through these a little bit because we've only got 5 minutes. Amanda's saying that can we mention the craft shops, which are important for dealing with departmental focused issues. Just to let people know, in the London production division, if you're a member, generally you'll be a member of a craft branch. So if you work in the camera department, you're in the camera branch, and you're an assistant director, you're in the AD's branch, and so on. In our regional production division, we do have craft shops. So that's there are people who get together as specific crafts with them. Please do find out about that in your local, your regional branch of the union. It'll help you keep up to date. We have got some good reps working in there who are watching all of the stuff that's happening centrally and passing it down. So if you're outside of London, you're in the regional production division. That's a way of staying on top of things. I've seen something in the chat from Leo Anna Thomas, and we always like to end calls with this, or as we're getting near the end of the call. A bit of good news. I'm about to trial the role of a wellbeing facilitator on a feature film from the 3rd of August. This role is designed to look after the mental health of all crew and cast. Leo Anna Thomas and Matt Longley of 6 Foot from the Spotlight and Mental Health in Film have developed this role and some mental health awareness training. We're about to have this all trialed. We've got the support of many industry leaders. Watch this space. This will be a new mandatory role to help support everybody. Thank you. Well, I think we can say, Leo, I think we can say that you've got the full support of the union in that. We would absolutely love to see that role spread throughout the industry. And we have many other things in mind that we've been talking about. So that's great news. Thank you. Thank you for that. 2 more minutes. Let's have a quick look. We have. I'm not going to. There are people talking about jobs that they've done abroad. I'm not going to answer that now. Yes, we are. Drew saying we definitely need. We need good examples. Matat saying I can't find. I meant to ask you this, Marion. I can't find the guide to atypical work that Marion mentioned in the website. Could I ask for a link? He's saying. Marion, where would we be able to get hold of that?
It'll be under the resources section of the website, and then there's a section on members' guides.
So this is the Prospect website, isn't it?
No, it's they're based on both websites. It's an original Prospect document. I'm not sure how to get the link to you very quickly, really.
Paddy, I'm asking Paddy. Paddy, can you keep an eye on that? Could you see if while we're finishing off this call, if you could find that and put that in the chat, that would be really useful. So it's under the resources section and it's on atypical working. Okay. Catherine saying, could we provide a link to the model questionnaire? Catherine, if you look at the page that has all of the safe working documents, you'll see that there is one on factual entertainment and outside broadcasting. It's that document. It's not the one that we've done for a TV drama and so on. We've done another bit of good news. So I think Anna's just repeated that one. We've got questions asking for very specific advice. By all means, please contact your branch official. If you just contact the union in the normal way, we can always provide direct advice. I'm just looking through to see John Howard. I'm going to make this the last one. I'm going to make this the last one now. John Howard saying, we've talked a bit about individuals being paid if they get sent home because of symptoms of a temperature check. But what's the advice on what to do about contracts that say if the entire production goes into hiatus, the worker will remain exclusive to production for 3 weeks. Spencer, what do you think about that?
Yeah, so the hiatus is it's not a new phenomenon for us. You know, we've seen it, you know, before in the past, you know, where they've put hiatus clauses in the contracts. You know, our position very clearly, and I don't know whether it's, I think it is detailed in most of the documents that we've published, is that, you know, production should, you know, compensate people whilst they're on that hiatus period. The contracts that I've seen for the hiatus it does say that you can't, you know, work for any other employer, but at the same time, we're not prepared to pay you. I don't think they can have their cake and eat it. Ultimately, our advice would be, if you've already signed that contract and you're bound by those terms, and they put you on the hiatus, but you get offered another job, I'd talk to your HOD and I'd say that you're giving notice to walk away from that job and take up a new role. Because to be hanging there for 3 weeks with no pay, I think is just unacceptable.
And we want to hear examples of it. You know, we would like to name productions that are doing it. I know that we're hearing that PACT are advising on this, and I think this is something that we're going to need to take up with them. Look, I think we have to finish now. There are quite a few questions we've not managed to answer, but I think we've answered as many as we can. I'd like to thank everyone for coming on this call. We've had over 200 people on this call, which is a great level of interest. I'd like to thank Marion especially. Marion is our legal guru from Prospect Union. She has to put up with nonsense from myself and Spencer day in, day out. You know, and you know, I mean, I think we've all got to extend our sympathies to Marion at this difficult time. All of these difficult times we've put through. Also, thanks very much, Spencer, for coming on this call. Spencer oversees all of our negotiations, and I think Spencer has forgotten more than most of us have learnt about dealing with issues like this. Finally, I'd like to thank Paddy Emmons, who's been anonymous there on the thing. You can just see a Bectu logo and Bectu comms. Paddy has been fielding all the stuff in the chat and encouraging people on the questions, and Paddy pulled all of this together. So I'd really like to thank him as well. But thank you all for coming. Do keep in touch through your branches if possible. Everything we do is about sticking together. So we can always achieve a lot more by getting people to stick together than we can by either asking employers nicely or asking Bectu officials to get in touch with them. Everything always works. So do keep in touch with your branches. They're really developing very well, and they have done some great work since March. So I'm going to end the call now, but thank you to everybody.
Can I just quickly just say, because there's some fantastic examples out there, some of which have been, you know, posted on here in terms of what, you know, what, you know, productions are doing. And the best way, we all want to improve the industry. We want to, you know, be more progressive in terms of, you know, what we're doing on the terms and conditions and things like that. So the more good examples that we've got that we can share with other productions, the better. And I think that's more effective than actually us just saying you need to change. If they've got examples out there where they can see productions are doing things and it's working for them, that's a really good way of changing minds. So I'd encourage people to send it through.
It is a really important point that sometimes when a member contacts us and calls out a production for doing something bad, and we amplify that, often what we do is we you know, not deliberately, we make it the norm. We almost legitimize it, and employers can say, well, you know, other people are doing it, so can we. So it is really important that some of the things that we amplify as when we're catching employers being good. And in fact, I would much sooner us to be constantly highlighting good practice than highlighting bad practice. Highlighting bad practice can, like as I say, can backfire. It can establish it as a norm and legitimize it. Okay. Paddy, could you capture the chat and everything before we finish the call? I'm going to sign off now. Thank you very much. Thanks to Spencer and thanks for Marion for calling in, and thank you for Paddy for managing this. Bye-bye.
Bye.
Right.